Objection, Judge. That's a prejudicial question. You want to know what this is about? Come join me in this walk through this deserted island here on St. Martin as I share with you exactly what this is about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, I'm here on St. Martin on the French side on a deserted island that my wife likes to call Shell Island. In order to get here, we had to walk all the way from back there in the distance, across all that rocky water, and now we're finally here. My wife loves to pick seashells, so she's off picking seashells, and I have a few minutes to share this great information with you. Okay, so now during the course of your trial, let's say it's a medical malpractice trial, you sued your doctor claiming that he was careless and that his carelessness caused you harm and injury. During the course of trial, the defense attorney asks you, the injured patient, a question. And now I believe that that question is improper, and the answer to that question, and even the question itself, I believe is prejudicial, and I think is going to influence this jury against us and ultimately give us a verdict against us. So what do? When I hear that the defense attorney is asked a question that's improper, what is my obligation as the attorney? I have to jump up out of my seat and I have to yell out, "Objection, Judge!" And I have to do it loudly. And then I have to tell the judge exactly why I believe the question is improper. So basically I'm saying, hey judge, listen, this attorney just asked a question that's totally improper, and now the judge wants to know why. What's the problem? Why are you interrupting the trial? So I have to give the judge a quick explanation of why I believe this particular question is improper. And in this instance, in this example, I'm saying that this question is prejudicial. Now what does that mean? Well, think about the word prejudicial. It's prejudging, basically. Well, think about the word prejudicial. It comes from prejudice, right? What's prejudice? It means that somebody has prejudged something. Now, it could be lots of different topics. It could be race. It could be religion. There could be many, many, many different things that could be prejudicial. So, in this particular instance, this defense attorney asked my client about a prior conviction that he had, something that happened 20 years ago. Now, you should know something very important. My client in this instance, in this example, did something stupid. He was arrested, he was convicted, he pled guilty, I should say, pled guilty and served his time. And now, 20 years later, he was involved in, and now 20 years later, this particular doctor caused him significant harm and injury. Why? Because his doctor was careless. And now he's here, and now my client is here trying to obtain money as a form of compensation for the doctor's carelessness and the harms that he caused. This has nothing to do with what happened to him 20 years ago when he really did something stupid and served jail time. So now, let me ask you this question. Should the jury be allowed to learn that information? Is this something that's going to affect the jury's ability to determine whether or not the doctor was careless and whether or not the doctor's carelessness caused my client harm and injury? The reality is that one has nothing to do with the other. However, the defense will certainly argue that it affects my client's credibility, and the jury should at least be able to learn about the fact that my client did something stupid, that my client pled guilty to the crime, and that my client spent time in jail, significant time in jail. Why do they want to show the jury that? Because they want to show that my client is not believable, that he has no credibility or very little credibility. And they believe that by showing the jury that my client did something stupid 20 years ago, he should not be believed in this particular case. Does that make sense? Well, the answer is yes and no. The reality is, the answer is yes and no. The reality is that in New York, the defense attorney is entitled to ask my client whether he was ever convicted of a crime or pled guilty to a crime. And we're not talking about parking ticket violations or speeding tickets. We're talking about significant crimes, okay? Certainly felonies, certainly misdemeanors. And in those instances, if the answer is yes, if he pled guilty, or if he was convicted after a trial, now the defense attorney can use that information to show to the jury what my client's past was like. Hey, this guy was an idiot. He did something really, really stupid. And yes, he did serve his time, but so what? He was an idiot back then, which means I want you to recognize that there's a good chance he's an idiot now. That's basically what they're trying to say, okay? So now, the moment I hear the question from the defense attorney, he turns around and says, hey, Mr. Jones, isn't it true you pled guilty to a crime of bank robbery 20 years ago? And now what do? I jump up out of my seat, I yell out, objection, Judge! That's prejudicial. Now, I'll tell you where that would make a huge difference. in the judge's ruling. If, in fact, my client had not pled guilty and had no criminal background, no criminal history, if the defense attorney were now to raise that particular question, what has he done? He's now poisoned the jury into thinking that my client has a criminal history, all because he asked a question about whether or not he pled guilty to a certain crime 20 years ago. The fact is, in this example, my client did not. So in that instance where he did not, now he has poisoned the jury into thinking that there's something going on with my client's history. Now the reason I'm objecting is because I don't want the jury to know about it. And that's why I'm saying objection, it's prejudicial. Well, that's not the case in this example that I'm using in this video. So in this particular case, yes, my client was convicted of a crime 20 years ago. He did his time, and the defense attorney yells out, and the defense attorney wants him to admit that he pled guilty. So now I yell out objection, that's prejudicial. And what does the judge do? The judge says, no, counselor, the jury is entitled to hear that. Go ahead and answer that question. And now, Mr. Jones, go ahead and answer that question. So what does he do? He goes ahead and says, yes, I pled guilty to that crime. I did something stupid. I served my time for it. Yes, I admit it. And now there's nothing else to cross-examine him about. So what happens then? So now the attorney has asked the question that is significantly prejudicial. So now the defense attorney has asked the question, which I believed was prejudicial. My client has now actually admitted all this stuff. And what happens then? Well, now the defense attorney will move on. And in closing arguments at the end of the trial, he's going to argue to the jury that my client is not believable. He's going to tell the jury, how can you believe this guy now if here you have a convicted felon? A convicted felon. You can't believe anything he has to say. Now, on the other hand, when I get up to make my closing arguments, you know what I say? I say, what does that have to do with anything? Yeah, my client did something stupid. I'm going to admit. Now, when I get up to make my closing arguments, what does that have to do with anything? The answer is absolutely nothing, and I'm going to make sure the jury knows it. I'm going to make sure the jury knows full well that one thing has absolutely nothing to do with the other. Why? Because what he did 20 years ago was certainly stupid. And yes, he admitted it. There's no contradiction here. And and the claims that are being made in this particular case, those are claims against the doctor for his carelessness. That has nothing to do with my client's credibility. The injuries that my client suffered, those are all confirmed by treating doctors. Those are all confirmed by the defense's expert, Those are all confirmed by the defense's experts and a doctor who they went ahead and examined my client who confirmed his injuries. So where is the credibility problem? And that's the argument that I will make to the jury. So does it matter? Is it prejudicial? In New York, the defense can ask that question. The judge will say it is not prejudicial. The jury can learn about it, and we move on from there. You know, I realize you're watching this video because you wanted to see the beautiful ocean, the ocean waves, the beautiful scenery in the mountains, and I'm glad you're with me. I'm really happy that you joined me today. But I recognize that you likely have questions about your own matter. Well, if you're thinking about bringing a lawsuit and have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.